5 seconds to go. Start. It would be too technical a view to take to defeat the complaint merely because the body of the complaint does not elaborate upon the authorization. The artificial person, being the company, had to act through a person official, which logically would include the chairman or managing director. Only the existence of authorization could be verified. While we turn to the authorization in the present case, it was a copy and thus does not have to be signed by the board members, as that would form a part of the minutes of the board meeting and not a true copy of the authorization. We also feel that it has been wrongly concluded that the managing director was not authorized. If we peruse the authorization in the form of a certified copy of the resolution, it states that legal action has to be taken against the respondent for dishonor of checks issued by him to discharge his liabilities to the company. To this effect, Mr. Bhupesh Rathod, Shashikant Ganekar were authorized to appoint advocates, issue notices through advocate, file complaint, verifications on oath, appoint constituent attorney, to file complaint in the court and attend all such affairs which may be needed in the process of legal actions. What more could be said? The finding by the courts below as to the lack of authorization to depose also thus stands nullified. The description of the complainant with its full registered office address is given at the inception itself, except that the managing director's name appears first as acting on behalf of the company. The affidavit and the cross examination in respect of the same during trial supports the finding that the complaint had been filed by the managing director on behalf of the company. Thus, the format itself cannot be said to be defective, though it may not be perfect. The body of the complaint need not be required to contain anything more in view of what has been set out at the inception, coupled with the copy of the board resolution. There is no reason to otherwise annex a copy of the board resolution if the complaint was not being filed by the appellant on behalf of the company. In our view, one of the most material aspects is, as stated aforesaid, that the signatures on the checks were not denied. Neither was it explained by way of an alternative story as to why the duly signed checks were handed over to the company. There was no plea of any fraud or misrepresentation. It does thus appear that, faced with the aforesaid position, the respondent only sought to take a technical plea arising from the format of the complaint to evade his liability. There was no requirement of a loan agreement to be executed separately, as any alternative nature of transaction was never stated. Stop.